Hi everyone, this is the third video lecture for LCC's clinical psychology class. Tonight we're going to be talking about forensic psychology. Forensic psychology is also known as law psychology. Forensic psychology is really any sort of psychology that focuses on working within the legal system, working as a part of the court or as a function of the court in some way. Forensic comes from a Latin term, which would mean of the forum, and this referred to the location of the ancient Roman legal courts, which took place in the Roman Forum. And so forensic is just a derivation of that Latin phrase. Forensic psychology is a growing field. There's been a lot of interest in forensic psychology in the last 10 years or so, and it's grown quite a bit. There's also a lot of interest in Europe. There are a lot of different conferences. There are even some conferences that have taken place in Lithuania. Mykolos Romeros University in Vilnius has hosted conferences on forensic psychology or law psychology in 2011 and 2012. I looked online, and it doesn't look to me as though they're still hosting that conference, but I know they had it a couple times, and they do have a law psychology degree there. So that's a master's degree, and so there would be some opportunities for those of you who are Lithuanian to study law psychology there. And I believe that's actually a degree that is taught in English, if I'm correct about that. So that's an opportunity for those of you who might be interested in this field. That would be something to check into. Also wanted to mention that if you would look up on the internet the European Association of Psychology and Law Student Division, or EAPL-S, there's a really interesting website there for that organization that includes actually a really nice resource, a collection of 2-page papers that summarize all the research on various aspects of psychology and law. And so that might be something you want to check out if this is a field that you're interested in. So I wanted to talk about some of the different ways that a clinical psychology would work within the legal system or work sort of around the legal system. The first thing is, or the first aspect that we could talk about is criminal competence and responsibility. And the first piece of that we'll break that into 3 pieces, but the first piece that we'll kind of talk about is this idea of people who are found not guilty by reason of insanity, not guilty of a certain crime because they were insane at the time that they were committing the crime. I did some looking on the internet. I could not find whether this is an issue in the countries that are represented at LCC and in Lithuania and some of the other common countries that you all are from, Ukraine, Russia, Moldova, places like that. I just could not find anything in English on, kind of how this works in your country. So I'd be interested to know if you know how this works in your country. Maybe send me an email. I'd like to know more about that. But in the US, the UK, and Ireland, and some Scandinavian countries, there's this idea that someone who commits a crime while they're insane, and we'll talk in a minute what insane means, but for now I think we all have at least a rough idea of it. And so the idea would be that if you've committed a crime, but there's something going on with you, some sort of mental illness that keeps you from understanding that what you're doing is wrong, that then you should be treated differently. And so in the U.S. we have this this finding or verdict that the court could issue that a person could be not guilty by reason of insanity, or we say NGRI for short as the abbreviation. One of the things that's really interesting in the U.S. is there's a perception among people, kind of just the common citizens in the U.S., that everyone pleads guilty, or almost everyone pleads not guilty by reason of insanity. And that's really not true. In actuality, it's a very rare defense, partly because it's not very successful. The textbook says that this is used in about 1 out of every 200 cases, and it's only successful in about 1 out of every 500 cases. So, if you're playing the odds, if you want to find a defense that's going to help you avoid punishment for a crime you've committed, this probably isn't the best way to go. And so that's one of the reasons it's probably not used more. The clinical psychologists come into this in one major way, and that's because they often serve as expert witnesses before the court. And so in the U.S., the way the system works is that both the defense attorney, the attorney who's acting as the advocate for the person who's accused of a crime, And then also the prosecuting attorney or the attorney who's trying to convict the accused criminal, they can both call psychologists as expert witnesses. And what they would want these psychologists to do is to determine whether the person who is on trial was incapacitated at the time that they committed the crime. Now, of course, these sorts of situations usually happen around the most serious crimes. Often murder is the one that you would hear this used with. Someone who's stolen a candy bar or, taken a few dollars from someone, they're not facing a serious charge, not facing a lot of jail time or a very terrible punishment. And so a lot of times this defense wouldn't be used in those sorts of situations. It would really only be used in very serious situations that could be either a very long prison term, life imprisonment, or of course in the U.S. we still have the death penalty, and so that's often a piece of this as well, is that the defense of not guilty by reason of insanity would be a tactic to try to avoid the death penalty. One of the interesting things is that psychologists can't testify as to whether someone's insane. And I know that nearly all of you have had your abnormal psychology class, and so you know that insanity isn't a diagnosis in the DSM-5. And so we can't say someone's insane because that's not a psychological term, that's a legal term. And what that legal term means is someone's incapacitated to the point where they're not completely responsible or they're not at all responsible for their behavior. And so then we have this idea that we shouldn't punish people if they're not responsible for their behavior, if they can't understand the morality of what they've done. Somebody who doesn't understand that they've really killed someone. They give an example in the book of someone who was accused of murder who had this belief that he could bring his victims back, that he himself would survive the death penalty and would wake up. And so this, you can see that this is often used in very, very serious cases, and it's often used around very serious mental illnesses. So these would be people that we suspect are psychotic, suffering from schizophrenia, something like that. So, a situation where they really can't understand what they've done. They really don't have an understanding of the impact of their actions. In the U.S., and I believe in the other European countries that use this verdict, if you're found not guilty by reason of insanity, then you receive treatment rather than punishment. And so in the U.S., a lot of times people think, oh, if someone's if someone's been found not guilty by reason of insanity, that means that they just go to a nice hospital instead of going for punishment. And that's somewhat true, but to be honest, often the hospital wards where people who are found not guilty by reason of insanity are kept would look, if not like a prison, they would definitely be locked units with security, and they're not fun, pleasant places to be. I actually had the opportunity a number of times to tour a forensic psychology unit in a state mental health hospital in Ohio, where I used to live and work in the U.S. And this forensic unit, which was part of the overall psychiatric hospital, they had a separate unit on a separate floor for the forensic patients. A lot of these patients had been there for years. They weren't getting out anytime soon. A lot of times these serious mental illnesses don't respond well to treatment, and the person is not ever going to be released by the court because the court isn't sure that they're not going to commit another crime. And so even though it's not called jail, it's really not like these folks are kind of just living a great life. So there really is, even though it's treatment, there really is some, if not punishment, at least some negative consequences attached to the action. So it's really different than how the public in the U.S. often perceives this. A second aspect of criminal competence and responsibility that's important to know about would be sort of a compromise. Some states are dropping this idea that someone could be not guilty by reason of insanity, or they're coming up with a compromise. They're saying, well, maybe somebody was mentally ill, but in many cases they're still responsible for their behavior. So we could sort of compromise and say that they're guilty but mentally ill. And so that would mean they'd still be incarcerated in a prison, but they can get mental health treatment while they're in the prison. Another similar verdict would be that somebody had diminished capacity. So someone who commits a crime while they're under the influence of drugs and alcohol, or whether while they're experiencing mental health symptoms that may not make them completely incapacitated, but might diminish or reduce their ability to understand the gravity, the severity of what they've done, then they might be found to have diminished capacity. So the most famous, or one of the most famous diminished capacity cases in the U.S. happened in the late 1970s when a man was found guilty of a crime. In the U.S. it's called manslaughter, which would be sort of accidental murder or murder through negligence, but not the same as kind of the usual way that murder is thought about. So manslaughter would be killing somebody because you've been negligent, or killing somebody by accident because of your, because of a mistake you made, but not as serious as a regular murder charge. Someone was found in the U.S. to have diminished capacity because they'd eaten a lot of junk food, and so this came to be known as the Twinkie defense. And of course, Twinkies are a kind of junk food that used to be popular in the U.S. I think they're still around. So the idea being that this person ate such an unhealthy diet that it kind of affected his ability to think well. And we know that psychologically there's some truth to that, but does that really kind of diminish his capacity to realize he shouldn't be killing people? That's probably a bit extreme. And so it's verdicts like that have made people kind of question the interaction of the mental health system with the legal system. So in some cases in the U.S., some states are kind of compromising and saying, even if we're not comfortable with this idea of not guilty by reason of insanity, we might be open to verdicts like guilty but mentally ill, or the idea that mental illness has caused a diminished capacity of the person to understand the severity of what they've done. The final thing that we want to talk about, or want to at least understand a little bit about criminal competence and responsibility, would be the idea of competence to stand trial. And again, this is a U.S. issue. I'm not sure how this is handled in other countries. But in the U.S., there's this idea that someone needs to be mentally aware and mentally stable to be able to stand trial, or for their case to go to trial. So this is different from not guilty by reason of insanity and some of the other things we've talked about, because in this case, we're not looking at whether the person knew what they were doing when they committed a crime that they're accused of committing. Instead, we're looking at, can they understand court proceedings? Can they respond to an attorney's questions? Are they aware of what's at stake in a trial? If they don't understand that the results of this trial could send me to prison for 20 years, they may not take it seriously enough, and that could really affect the outcome of the trial. So we want to make sure that people have some level of, have achieved some level or operating at some level of mental capacity in order to stand trial. And so that's another thing psychologists could be called upon to assess, would be whether the person that's being accused of a crime is in a situation where they could actually stand trial and could understand what's happening at the trial. And as I mentioned, this is different from not guilty by reason of insanity and some of the other situations. One of the ways it's different is it's easier to determine whether somebody's competent in the present, right? If we're determining competence to stand trial, we're looking at today, tomorrow, next week. Do we think this person's competent to stand trial? Very different when a psychologist is asked to testify about a person's mental capacity 2 months ago when they committed a murder, right? Because we're kind of basing that evaluation or that assessment on the person's self-report, on the report of eyewitnesses, on psychological testing. But again, that psychological testing didn't take place at the time the crime was committed. So actually, it's a little bit easier to determine competence to stand trial than it is to determine insanity and some of the other defenses that we mentioned. Okay, so I've talked some about criminal court and how clinical psychologists, how forensic psychologists might be involved in that. But there's also this thing called civil court, and civil court is involved when there's a sense that one person has caused another person some sort of injury, not in a bodily sense, but usually monetary injury or something along those lines, maybe interfered with their business. Or if we have concerns about a person's behavior that don't rise to the level of criminal actions, that would also be a civil court issue. So one of the things in the US that happens in civil court is sometimes the court has to determine whether a person is competent or what we call whether they have civil competency. In this case, we're trying to figure out, is this person capable of acting in their own best interest? So you might ask, when does this come up? A couple examples. If someone has signed a paper saying, if I'm in an accident, I don't want extraordinary medical measures. I don't want to be intubated, meaning have to be fed by a tube, to be on a breathing machine. I don't want to be kept alive in a vegetative state. If somebody has made a will, in all those cases, before somebody makes those sorts of decisions, we need to know that they're acting in their own best interest, that they have competency to make those decisions. So this often becomes an issue in end-of-life cases. It becomes an issue when a wealthy person passes away and doesn't leave money to people who expect to receive money from him or her. Often those people then will sue and say, oh, they weren't in their right mind when they made this will. And so then that becomes an issue for the court. Sometimes psychologists are brought in to try to determine whether that person is or was competent. And so the law in the US says that a competent individual must meet 4 characteristics. They have to understand the basic information related to making the decision, the details related to the decision. They have to be able to apply the information that they know to a specific situation and to be able to anticipate the consequences. They have to logically and rationally be able to evaluate positive and negative aspects of various decisions, and then they need to be able to communicate the decision that they've made. And so, psychologists might be asked to evaluate people in those criteria. Could a person meet those 4 criteria? And if so, then they generally be judged to be competent and to be able to act in their own best interest. Another thing, and these are not very common, but your book mentions them, so I just wanted to explain a little bit what they were. Another thing that clinical psychologists might be asked to do that relates to the court is what's called a psychological autopsy. And this is often when a clinical psychologist is asked to determine if a death was a suicide. And you might think, well, why is a clinical psychologist brought in on that? The issue is that, at least in the US, insurance companies, if someone has life insurance that pays their spouse or their family a certain amount of money if they die, that money is not paid if the person commits suicide. And that's done as sort of an incentive to keep people from committing suicide. So there's a concern that maybe if someone has life insurance and they lose their job and their life's going terrible, and maybe they're on the verge of losing their house, maybe that person would commit suicide so that their money could keep, or so that their family could keep the money, or would get the money from the life insurance policy and be able to keep the house and be able to go on living their normal lifestyle. And so insurance companies want to avoid that. So these insurance plans or contracts usually have a provision that says that people who commit suicide, their families don't receive that insurance money. And so sometimes clinical psychologists are brought in by courts who are seeking to determine whether this money should be paid or not. And, as you can imagine, because these are psychological procedures that are done after someone's dead, trying to determine the state of mind that someone was in when they died and the reasons behind their death, there's a lot of questions about their validity, and judges have mixed reactions. There's sort of some uncertainty among judges about whether they should rely on these psychological autopsies or not. But psychologists sometimes do get involved in that sort of thing, so I wanted to mention it. Something else that psychologists sometimes do in relation to the criminal justice system would be what's called criminal profiling. And if you know anything about forensic psychology, this is probably the thing that you know about. There's really a misperception out there that a lot of psychologists are involved in criminal profiling. This is actually very, very rare. I think the misperception is there because there have been some very popular profiling shows on television. CSI, I think, is one, Crime Scene Investigation, and some other shows where they have a psychologist on the show who's always helping the police to figure out criminal cases. The true side of all this is that sometimes criminal profiling is successful. Your book has an interesting short story about Dr. James Brussel and how he assisted in capturing somebody who was known as the Mad Bomber, a man named George Metesky. And what Dr. Brussels did, was actually very amazing. He actually even was able to describe the type of clothing that this George Metesky wore. race, or I'm sorry, his national background. He was originally from Eastern Europe somewhere. Described who he lived with, all kinds of things. So it can be successful, but the truth is it's often inaccurate. And for every case that's successful, there are usually multiple cases where it's either partially, where the profile is either partially or totally inaccurate. So everyone gets really excited about criminal profiling, partly because it's kind of entered popular culture through TV shows and that sort of thing. But not a whole lot of psychologists are doing this. There's a lot of questions about the validity of it. It's often not accurate, and so it really isn't something that for most psychologists is a viable career. But some people do it and are involved in it. Another way that psychologists might be involved in the court system would be around issues of child custody and parental fitness. And so one of the things that happens sometimes is, parents will either get divorced, or if they were never married, they'll split up. And then there's often some dispute about which parent gets to raise the children. And in the US, this often becomes a matter for the court to decide. And so clinical psychologists are sometimes called in to determine a number of things related to which parent gets to have custody or have the child live with them. Sometimes one parent will make an accusation against another parent and say, you've done some things that make you unfit to have any sort of contact with our children. And so then clinical psychologists have to come in to determine whether there's parental fitness, whether the parents are actually fit to raise the children. If there have been some sort of accusations of abuse or negligent conduct or that sort of thing, psychologists often have to try to figure out whether this is something that should disqualify the parent from being able to raise or from being able to parent their children. Sometimes it's not quite so serious, and it's just that each parent wants the child to live with them, and then often a clinical psychologist has to come in to determine which parent they feel is a better fit for the child. Again, that's not an exact science, sort of like some of the other things we talked about, and so it's really a psychologist using his or her clinical judgment to say, based on a multitude of factors, here's why I think this child should live with the mother or with the father. Clinical psychologists could also serve as custody mediators, and this would occur when two parents are disagreeing about who would have custody. The clinical psychologist might be able to do sessions with them and help them come to some sort of agreement. In the US, we have increasingly cases of shared custody where children live part of the week with one parent and part of the week with another parent. I personally have some concerns about that kind of instability and that kind of transience where a child's living one place for a few days and another place for a few days. But that's become increasingly popular here in the US. And, it's something that a psychologist might be able to help parents kind of negotiate as they're splitting up. The other thing that clinical psychologists do in this regard sometimes is helping parents to figure out how to parent together even after divorce. I have a friend who's divorced, and she has told me a number of times how intentional she and her ex-husband have been about parenting their children in the same way. And that's had some pretty good outcomes for her children. Unfortunately, a lot of parents don't do this, and often they kind of disparage the other parent, and so there become issues with the children disrespecting one parent while with another parent and that sort of thing. And so that's obviously something that clinical psychologists could get involved with that's kind of related to the court because it's related to divorce proceedings, which go through the court system. So those are some other ways that clinical psychologists could be involved in the court. These are much less high profile than something like criminal profiling, right, which sort of captures everyone's imagination. But there are roles that clinical psychologists play. Okay, I wanted to mention a couple of the things that are either discussed very briefly in your book. I wanted to go into a little bit more detail than your book does, or in one case, one of these topics isn't really mentioned much at all. I wanted to talk a little bit about correctional psychology, and this would be when psychologists work in prisons or other correctional facilities. And you can imagine, if you're locked up in prison for years and years, your psychological situation, psychological health is probably not the best, right? There are some problems with being locked up in prison. That's not an environment that nurtures people, that causes human flourishing. And so, we know that often people in prison need clinical psychology, they need counseling, they need some sort of therapy. And so some correctional facilities will actually hire psychologists to work there, at least in the US and in some countries. I've gotten the sense that this might be less common in Lithuania, partly because I was talking to one of our LCC psychology graduates, Yeva, who just graduated a year or so ago, about a year and a half ago. And she's actually working on developing a program that's going to go into prisons and work with prisoners, to try to help with educating them and that sort of thing. And she and I had tea together while I was at LCC recently, and she was telling me about how few services there are for inmates in Lithuanian prisons. I also know that Dr. Eric Hinderleiter and Mr. Tom Frank, who teach in the business department, have been involved in educating prisoners in Lithuanian prisons. I've also gotten the sense from some comments they've made that there aren't a lot of services for prisoners in Lithuania. So this might be something that kind of develops over time. As I said at the beginning of the lecture this evening, there's actually a lot of interest right now in Europe and in Lithuania in legal and forensic psychology. And so this might be something that we see more of. It might be actually an interesting field for some of you to look into. Well, if you're trying to do clinical psychology, if you're trying to do therapy in a prison, you're often a member of the prison staff, and so then there are often difficulties establishing therapeutic rapport with your clients. And this is because the psychologist is often seen as a member of the prison staff and seen as a member of the correctional staff, and so then it's seen by prisoners as kind of a part of the enemy group, right? This is the group that's keeping us here, the group that's locking us up. In the US, a lot of times psychologists and other helping professionals in the prison are told, your job is as a prison guard first, and then whatever else you do after that. And so that sort of mentality, the inmates, the prisoners pick up on that, and they kind of think, is this person really on my side? And so we know in psychology, we know the importance of empathy, of developing rapport with our clients. And so being in a prison situation often makes that difficult. And so this is why some of the things we've talked about in class, like motivational interviewing, this idea of rather than trying to force an outcome on a client, rather than that, trying to help them to find their own motivation, to change, to do things differently, and trying to let them dictate the pace of that, control the pace of that change. Those sorts of approaches tend to work better than very directive, results-oriented approaches with prisoners. Because if you do the more directive work, they'll often just kind of shut you out, and they'll think, well, here's another person trying to control me in a situation where I'm controlled all the time. So I mentioned MI, or motivational interviewing. There are some other therapies now that are just generally called motivational enhancement therapies. So MI is probably the most famous, but there are some other approaches that would kind of work in a similar fashion. The other thing I wanted to mention that's sort of an interesting conversation is the ethical problems of psychologists working in prisons. So even though we might work in a prison from the best of motives, we want to make a prisoner's life easier, we become part of the system that ultimately isn't really good and healthy for the person there. Sometimes it's necessary. Some people need to be in prison. Some people are dangerous. But even then, prison isn't the best thing for them personally. We're putting them in prison to keep them from hurting someone else. And a lot of the people who are in prison, frankly, probably don't need to be there. People who've been convicted of drug offenses, people who've been convicted of minor nonviolent crimes, may actually do better with community correctional approaches, things like probation, restitution, community service work, those sorts of things. Prison often makes people worse. It often takes somebody who's a small-time criminal, puts them in a situation where people who are the strongest and the biggest and, sometimes the smartest sort of call the shots and have a lot of power. And it often teaches people how to be better criminals. That's not the way the real world works. That I don't move up most places because I'm stronger than everyone else. But in prison, being strong, being a member of a gang, those are often the things that kind of get you ahead. And so part of the problem, one of the ethical problems with psychologists working in prisons, is you're working in a system that actually rewards dysfunctional antisocial behavior often. And just for an example, I've worked with prisoners, and that's actually been a big part of my work when I worked in substance abuse. And I remember one prisoner telling me one time about when new people would come into the prison, usually one of the biggest guys would grab them and say, I want you to take your fork or your spoon, I want you to bang it against the bar of your cell all night long. And if I hear that clinking of the fork or the spoon against the bar of your cell stop, I'm going to beat you up in the morning. I'm going to beat you to the point of almost dying. And so these scared people would sit there, would stay awake all night long their first couple nights in prison, just banging their spoon against the bar of the cell door. And so you can see that's the kind of thing, the kind of psychological harassment, the kind of physical intimidation that doesn't lead to healthy psychological outcomes for people. And if we're working in a prison, we're part of a system that at least allows that to happen and often doesn't really do much to stop that from happening. There's actually been some interesting research on this. A sociologist named Irving Goffman in the mid-1900s did some research on institutions like prisons, mental institutions, asylums, as they were called back then. And what he came up with was this idea of total institutions. And he said a total institution is an institution that controls all aspects of a person's life. And Goffman said most of us, we go to different places to work, to have recreation, to sleep, to socialize. When you're in a total institution, every aspect of your life is controlled by that institution. And we know that that actually doesn't lead to a positive outcome for people. Again, sometimes it's necessary because people are dangerous to themselves or to other people, but that's usually not the best situation for a person. That doesn't lead to human beings thriving and flourishing. And so Goffman actually referred to this as a type of civil death, where the person is still alive, but in some ways they've become a non-person. They've lost their identity. Often they become an inmate number. They become just one piece in kind of this total institution. And so even though they're still alive, they've sort of died what Goffman called a civil death. They're not really living anymore in a lot of ways while they're in the institution. And as psychologists, we need to think about, can we go work in these kinds of institutions and be part of positive change? Or are we going to be co-opted and kind of drawn into the systems in those institutions? The truth is, most times when we work in those kind of places, we become part of a very dysfunctional system. Again, sometimes it's a necessary system. Some people need to be there, but it's not a very humane, dignified system that leads to people flourishing and doing well. Another example of the reason that psychologists need to think long and hard about how involved we can be in prisons would be the Stanford Prison Experiment. If you haven't heard of this, you should Google this. There's actually a whole website devoted to it with recordings and information from the actual experiment. So I think many of you have probably heard about this, but in case you haven't, Philip Zimbardo was a very well-known professor of psychology at Stanford, one of the top universities in the US, one of the top universities in the world, actually. And he developed, I believe it was in late 1960s, developed an experiment where he randomly divided a group of college-age students into prisoners and guards, and there was complete random assignment to group. He turned his psychology laboratory into a prison. He had the doors removed, had barred doors put on, and basically one of the things he found was that within a few hours of the experiment starting, the guards were mistreating the prisoners, and they did some pretty bad mistreatment. It wasn't they were beating them physically, but they humiliated them, they made them strip naked, they made them do sexually suggestive acts with each other, and these were all males. They deprived them of sleep, they used psychological torture and hazing on them. One of the very interesting things about this is that Zimbardo, who was a PhD psychologist who designed the experiment, he writes very honestly, and I give him credit for this, he writes very honestly about how caught up he got in this experiment, to very quickly he came to see himself as the warden of the prison rather than as a psychologist. And so even in a situation like that where he clearly had a lot of control, he could call off the experiment at any time, he was a psychologist who got drawn into this prison psychology. And I think there's a real danger that psychologists working in prison could have that happen, where they become part of the prison system rather than an element that humanizes or betters that situation. So anyway, I think you get the sense of what I'm saying there, and I'm not against psychologists working in prisons, But if you choose to do that, and there's a real need for it, but if you choose to do it, you really want to make sure that you're in a situation where you don't get drawn into that institution, and where you can kind of be someone who promotes good, who promotes human flourishing, rather than just kind of holding people down while they're in prison. Okay, the last thing I wanted to talk about is also related to how psychologists interact with the court system, with the legal system. And this is maybe not quite so applied, but some clinical psychologists actually study the reliability of eyewitness testimony. Most legal systems or most legal decisions in most courts are made quite often on the basis of eyewitness testimony. Someone who saw a crime committed identifies the perpetrator of the crime, and then that person is prosecuted and ultimately found guilty. But there are a lot of problems with eyewitness testimony, and I want to divide these into estimator, or we could say witness problems, and system problems. Problems with the estimator or the eyewitness, estimator would be kind of the research term for someone who's seen something, would be that often it's very difficult for them to identify accurately who committed the crime. And some interesting research findings on this, we found that eyewitnesses are better able to identify members of their own race than they are of different races. We also find that the accuracy of their identification of a criminal is diminished by high levels of stress. So the more violent the crime is, the more stressful the situation was, for most people, they're going to feel a great deal of stress, and their ability to identify the person who committed the crime is going to be decreased. Also, we know that accuracy decreases quite a bit if a weapon is involved in the crime. And we think the reason for this is that the person's attention is focused on the weapon. If someone has a gun, you're watching the gun, you're not looking at their face, and so it's going to be harder to identify them. There are also some things that we can do. Obviously as psychologists, we can't do much about eyewitness reliability, except to make people aware that eyewitnesses may not be very reliable, and that there are certain factors that lead them to be even less reliable. But there are some things we could do to try to improve the system and the factors associated with the system, with the legal system. And so one thing we know now is that, in the movies, a lot of times after a crime's been committed, the police bring in 5 or 10 people, line them up in a row, and they have a witness identify the person who committed the crime. We know now that that's actually not the best way to do that. Actually, bringing out one person at a time rather than having them in a large group tends to lead to more accurate results. Also, we know that the instructions that we give the eyewitness can help them to be more accurate in their identification. So if eyewitnesses are told the offender may or may not be a part of this group of people, they tend to make a better decision. They tend to make a more accurate identification. If they have to decide from one group, if they have to pick one person, they tend to do that. But if we give them the liberty not to pick a person, if we say the person may not be here, they tend to more accurately decide whether the person is actually there or not. The other factor that we can sort of control, not always, but to some degree, would be the length of time between when the crime's committed and when the interview takes place, when the eyewitness is interviewed by the police. And so one of the things we can try to do is get eyewitnesses into the police station and have them identified as soon as possible after the crime, because we know the longer the time after the crime, the less accurate that identification is. The other thing we can do is we can try to teach police officers about interviewing techniques. There are certain ways that police officers interview witnesses that seem to kind of plant an idea in the witness's head, and then it's easy to get the witness to identify a certain person. And so we want to make sure that police aren't using interviewing techniques that kind of lead witnesses to making certain decisions or identifying certain people as criminals. Okay, so those are some of the ways that clinical psychologists interact with the legal system, the court system. Again, this is a field that you might want to check out. There's a growing interest in it, and increasingly I'm hearing about programs both in the US and in Europe that train people to work in the court system. Hope you guys are doing well. Again, as always, if you have questions, if you have concerns about the lecture, about the quiz, please just send me an email. I'd be glad to interact with you about that. And I will be back next week when we'll be talking about the next topic, the next lecture. Okay, have a good week, guys. Bye now.